Thank you, everybody, for joining us this afternoon for our webinar, Effectively Litigating Against Defective Products. I really appreciate you joining us. I think this is going to be a great session. My name is Paul Myers. I'm the CEO and Chairman of Advocate Capital. Been with the firm for over 20 years, primarily in credit and operations. Just took over as CEO about 9 months ago. So I'm still learning a little bit, especially about the webinars. I hope I get through this okay. Our marketing team's did a great job of getting this set up. And the best news is we have a fabulous guest, Lance Cooper, who is an attorney and founding partner of the Cooper firm down in Marietta, Georgia. Read you a little bit of Lance's bio. Lance Cooper is a founding partner of the Cooper firm and represents clients in catastrophic injury and wrongful death cases. He specializes in product liability cases involving automobile design and manufacturing defects. Lance has been lead counsel for plaintiffs in a large number of jury trials, including trials against GM, Ford, Toyota, Kia, Chrysler, Honda, as well as other motor vehicle manufacturers and large corporations. His 2011 wrongful death case against General Motors, Melton v. GM, exposed the cover-up of the faulty ignition switches that resulted in millions of recalled vehicles. He successfully prosecuted hundreds of cases and has received numerous multi-million-dollar jury verdicts and settlements. He received his law degree from Emory University in 1989, where he was a G. Joseph Taro Scholar and editor of the Harvard Journal of Law and Public Policy. He received his bachelor's degree in political science and economics from the University of Cal at Berkeley in 1985. He has served as past president of the Georgia Trial Lawyers Association and as a past president of the Cobb County Trial Lawyers Association. He's a member of the American Association of Justice and was honored to receive the Stephen J. Sharp Public Service Award in 2014. He was also a 2014 nominee for the Public Justice Trial Lawyer of the Year Award. I really appreciate Lance taking the time to join us today. Lance, thank you.
Thank you, Paul, for allowing me to be here.
Lance, as you can tell, is a renowned expert in this field, and we're thrilled to have him on. We hope it'll be informative. Quick disclaimer, this webinar is for informational purposes only. It's not intended to provide and should not be relied on for tax, legal, or any accounting advice. Anytime you have any questions about that, you should consult your own legal or accounting advisors before taking any actions. With that said, we'll kind of jump into the content. And I did want to let you all know a couple of logistical items. As we go through this, if you have any questions, there's a question function in your app where you can type those questions in. We'll get to them sometimes maybe during the course of the webinar, but we have a session at the end of it to address any questions that come through. So feel free to jump in there. If you have questions about anything you hear, please type that in and we'll get to them. Also, if you forget anything we talk about or anything like that, don't worry, we're recording this and we'll distribute it to all of the attendees via email some point in the near future. So those are a couple of logistical items. Thank you so much again, and we will jump right in. I guess, Lance, the first step in litigating against defective products is trying to figure out what makes a strong product liability claim. And I guess, how often do you think lawyers overlook these types of cases?
Well, as most of your audience, I'm sure, knows, you really have two different types of product liability claims. You have design defects and then you have manufacturing defects. So for example, in a manufacturing defect case, a component part fails. And those are really oftentimes the easier cases to identify because your engineer can come out and see that a tire failed in a way it shouldn't have failed, or some component part on the vehicle failed when it shouldn't have failed. And you really start obviously by, you retain the evidence. In other words, in this case, if we're talking about an automotive vehicle case, you retain the vehicle. And what I normally do is go out there with our paralegal and actually initially look at the vehicle to see if we see anything that's a problem. So our initial look oftentimes doesn't involve an engineer. It just involves us going out and looking at the vehicle and seeing, with our experience, is this something that shouldn't have happened? So for example, if you have a crash where a rear end crash, where there's a passenger and a driver, and the passenger walks away from the crash and the driver for some reason sustains a catastrophic injury, we look at that from the perspective of there's some asymmetry here. Something happened that apparently shouldn't have happened. And then we get into, at that point in time, hiring the experts and making sure that the experts can support our particular claim. Now, the reality in these types of cases is oftentimes identifying a strong product liability case, or all the time, includes what are the damages. Because if you're suing these large automotive companies, unless you have some sort of catastrophic injury or fatality, oftentimes you just can't. It doesn't make any financial sense to pursue the claim. We get cases where an airbag doesn't work, and it probably should have worked, and someone sustains some moderate injury. Unfortunately, we tell the clients or the potential clients, you can notify the government about the defect, you can notify the manufacturer, but we can't pursue that claim on your behalf. And so, that's from a big picture standpoint. Identifying a product claim involves, your legal acumen, your legal experience, and determining, is this something that looks like a claim, and then ultimately getting to the engineers or the other experts to come in and be able to tell you, yes, your instincts were right, it is a claim, or no, for whatever reason, it's not a claim.
Okay.
Now, with respect to overlooking product liability cases, and this is really, I've seen this in so many cases over the years. I'll give you an example of a recent case we had here come into the office, and it was a tractor trailer rear-ended a sedan, and a young lady was driving, and she died in the crash. And the lawyer who had the case settled the company with the tractor trailer company, which is understandable. The tractor trailer company was acknowledging responsibility, and then that lawyer came to us and said, do you see a product defect case? And you always would rather have the case up front because there was some evidence that's no longer available that needs to be available. But we're looking at that case both from a seat back standpoint, because in that case, the sedan seat failed, the driver's seat. The driver went into the rear, who was belted, went into the rear of the vehicle and hit her head and sustained a fatal injury. And she was wondering if there was a seat back case. But what we did in our investigation was realize that this tractor trailer, the tractor in particular, didn't have any sort of forward collision warning system on it. And so there's this new technology out there, and it's not that new, but it's been around a while, and it's basically to avoid crash avoidance technology. And in this case, tractor trailer companies for a decade or more, they've had tractor companies have had the technology available to put on a vehicle. So if a driver's driving down the road and he's distracted, and all of a sudden there's a car in front of him, he didn't have time to stop, this warning system, and some of you may have it on your cars, it'll begin to alert you, and then you'll end up not only alert you, but then it'll break at times if you don't react quickly enough. And so we told her, we need to look at this particular case, and we think it's going to be ultimately a very strong case. One of the problems is the vehicle tractor is no longer available. So to get to practice pointer number one, even if you get a case in the door and you think you have a good liability claim against the defendant driver or some other, it's critical to, when you're looking at a potential product case, not to wait and say, well, I'm going to settle the underlying case and I'm going to call a product liability lawyer. So in this case, obviously, we're not going to, we still think we can pursue the claim, but it's going to make it a more difficult claim to pursue. Right. And so I think that a lot of times lawyers may not be overlooking a product liability case, but that they don't get lawyers involved enough. But in this particular case, and I'm sure it happens all the time now, we've seen it a few times with this new crash avoidance technology. For example, in rear end crashes, in every one of those cases, if the harm is serious enough, the lawyer should be looking at, well, is it a potential for this for the manufacturer to be sued for not having this technology available? I know that's a long-winded answer to a short question. I apologize.
No, it's a fabulous answer. I appreciate it. That's great information. Moving along to, and I think a lot of what you just talked about ties into some of our next topics about what steps you go through in pursuing a product liability claim. And you just touched on it a little bit, but how do you properly retain evidence, or I guess obtain and retain evidence?
Yes, and I did touch on it a little bit, but to get in a little more detail, because it's critical, when you get a product liability case in, it doesn't just mean retaining the vehicle or whatever the product is. It includes sending your experts out to the scene to do the preliminary investigation and gathering what evidence is at the scene, because some of that may ultimately be helpful. It includes, of course, retaining the vehicle, and then it also includes maybe retaining not the vehicle your client was in, but the vehicle that hit your client, so that the whole reconstruction can be conducted in a way that can allow you to determine whether you have a case. And that's the real rub here, is that can cost, and in our routine investigations probably cost in excess of $10,000, even before we have decided whether or not we're going to take the case. But we take the position with the potential client, we owe it to them to investigate this case as much as we can in order to give them an honest opinion. Now, some cases come in and we say, hey, we've looked at this preliminarily and we just don't think there's a case here. But if we feel like it's worth investigating, if it's worth investigating, it's necessary to spend the money to do a full investigation. Even on the back end, you tell the client we can't help you because you've done the client a service there. Now, it may cost you money as a law firm. It will cost you money. But it's critical to do that, because if you don't do that, as in this case I talked about the tractor trailer case earlier, it really could bring harm to your client, because if you're thinking, well, I'm going to wait until this or wait until that before I retain this evidence, it's a product liability case, which means you're alleging a product's defective, and in order to allege that, most of the time you need the product, and then you need all this other evidence that's part of the investigation. And we have a tire case in the office now where early on the troopers did a thorough job. Early on after the accident, we sent our own investigator out there, and he gathered all these tire remnants, and there were ultimately tire remnants that were part of our tire that they didn't uncover that have been helpful to the case. So it's critical to do that, the early work and the hard work of retaining as much evidence as possible to give your engineers, your experts, the ability to evaluate all that to determine whether it's a product liability claim that should be pursued. And then I think the next point was on the experts, and I'm sorry, not to get ahead of you.
Yeah, I guess you touched on it a couple of times, is directing, how do you direct your financial resources in a case? Because as you said, it can be expensive just to do the preliminary work, much less if you decide to take the case after that preliminary investigation. How do you direct your financial resources in a case to successfully take on manufacturers and their insurers? Because as you know, the manufacturers and insurers have extremely deep pockets, and sometimes you have to be very strategic and thoughtful about the way you use your financial resources. Can you touch a little bit more on that?
Sure. We have two tracks. One is with these initial investigations I just spoke about. That's sort of our in-house money, so to speak. In other words, we just have money in the office, in the accounts, to where we're committed that if we tell a client we're going to investigate, we spend the money. And at the end of the day, if it turns out we spent $1,000 and we can't bring the case, then we absorb that cost. And that's it's a pretty basic approach. And then, of course, when we file or we decide we're going to pursue the case, that's where your Advocate Capital gets involved, or we get involved with them. In other words, we're allowed to work with Advocate Capital in order to help our client pursue her case as well as it should be pursued. And you made the point, we're not GM, we're not Ford, but in our litigation, we do as much, if not more, than GM or Ford as far as the resources that we put into a case in order to make sure that our client's adequately represented. And I think that's obviously critical. In none of our cases do we, we're not spendthrifts. I mean, we don't spend money foolishly, but in none of our cases do we ever say, well, we don't want to do this because it's going to cost too much money. Because if you're in that position, then you're basically in a position of saying, hey, we're going to allow the other side to have a leg up because they have the resources. And again, we don't spend money foolishly, but and we've done this long enough to know how to spend the money wisely, but you still need to spend it. I mean, in the recent product liability cases that have gone to trial, we've had, I think in all of them recently, we've had over $500,000 in costs in the case because it's extraordinarily expensive now. And engineers, I mean, they're not cheap, and you got to invest the time and the money. On the plaintiff side, you got to do the testing, you got to be sure your experts are dauber proof. All that just takes a lot of time and effort, but at the same time, it's worth it, because at the end of the day, the vast majority of our cases either resolve successfully either through settlement or a trial.
Great. Well, good. And you're right. They are extremely expensive, but you're going up against defendants with extremely deep pockets, and you can't really cut corners. Like you said, you need to be wise about how you spend your money in almost everything you do. But there is the adage, you have to spend money to make money, and this is one of those times, I think. So I appreciate that insight. I guess moving on, the next step would be, how do you find the right expert witnesses?
Well, in our situation, since we have this experience, we have, for lack of a better word, a stable of experts. But if you're relatively, but the reality is, for example, in this consumer or crash avoidance technology litigation, you're talking about, it's not an airbag failure where we have an airbag expert. We've had them for a number of years. It's not a seatbelt failure. It's something new. And so we've actually had a trial and error process, and that is, we initially reached out to lawyers, and I would say that's the first step, is reaching out to other lawyers in the field, because they've vetted these experts. Right. But there's always a dearth of experts on the plaintiff's side. I mean, the manufacturers can call up whoever, in-house or outside engineers. There's always a dearth of experts, and so there's always room for more experts. And so what we do is consult with other lawyers around the country we work with. We have some resources, including a gentleman by the name of Sean Kane at Safety Research and Strategies up in the Northeast. He has access to databases and identifying experts for us. And then in this crash avoidance technology, it's really beating the bushes. I mean, we identified some experts early on that weren't that favorable, but we've now found, through basically just a lot of looking at Google and what articles, who's written articles about this, are they engineers, what is their involvement, and do they have the expertise in that particular field. And tire experts is another example. The best tire expert in the world, I believe, is in Australia. And some enterprising plaintiff's lawyer here in Georgia about 7 or 8 years ago read about this guy in some periodical, so called him up. And the next thing you know, he's just a fantastic expert. Used to work for the manufacturers, or a manufacturer, and has very solid credentials. And so that's really the best way to do it, is to if you can't find it through other lawyers or through any sort of resource you ultimately have, is just start looking at the periodical, looking at the journal, looking at whatever it is that particular technology. There's articles or expertise about it, and we've been able to been successful in finding experts in those areas.
Well, it's amazing you found a tire expert in Australia. You never know what you're going to turn up. That's pretty interesting. Listen, before we move on, just another logistical point. I think someone in the audience had a virtual hand raised. I don't know that I can actually see that, so I encourage you, if you do have a question, just go ahead and type it in the question box and send it on over, and we'll get to all of them as we go through the webinar, or at least at the very end. So thank you. I guess finally, a very important point, Lance, is how do you determine, or how can you prove, if a manufacturer actually had knowledge of the risk of their product?
Well, that's where you get into discovery. And okay. And it doesn't mean just discovery from the manufacturer. It means discovery from, again, these resources I've talked about. So let's do 2 tracks here. One is in discovery outside of pursuing discovery against the manufacturer. And so let's talk about that. So when we get a case in, we usually call Mr. Kane up, and he does a search of the federal database as far as the National Highway Transportation Safety Administration and other databases. And then the Insurance Institute for Highway Safety, all of these databases that we are aware of that track crashes and track other incidents, so to speak, because, and it goes without saying, but I think it's important to remind ourselves that whenever you have a crash that results in an injury and you sue a car company and you do a focus group, the first question the focus group members ask is, has this happened before? Has this ever happened? because they want to know, is this a fluke, a freak accident? Because that's what the manufacturer is going to say. And
Right.
so early on, we tailor it to, are there other incidents out there or other complaints or anything that the manufacturer knew or should have known about? And then when we get into the litigation, we have a process of discovery, and obviously in every state, but we have a template that we use in every case, and that is we file the lawsuit and we file discovery with the lawsuit, and we are dogged in our pursuit of discovery. So when we file a lawsuit in discovery and the discovery is due 30 days out and the manufacturer asks for an extension, we give them an extension. And so we allow them to basically give them the rope to hang themselves, because ultimately what they do after the extension is you don't get any responsive documents initially. And so our approach is, all right, then we send the letters demanding they produce the documents. If they don't do that, we have a time frame in which we file the motion to compel, and it's just on and on. And I think defendants rely upon plaintiffs' lawyers either being lazy or extremely busy. And so they don't follow up like they should. They've got 20 cases in the office when they only should have 10, or they have 20 cases in the office, but they like to golf a lot in the afternoon. And so they don't spend the time on the cases. And I'm guilty of that. I've at times had too many cases in the office because it's always hard to turn down the next great case. But what that does is it detracts from, you're pursuing your current cases. And so, for example, with our paralegals, we assign them to specific cases. We don't have them doing tasks. And this case is your case, our case together, and this is our plan. And if the manufacturer doesn't, and you see it in almost every case, the defendants do not want to give you the documents that they have. Because ordinarily, when something bad happens in a case and it's out of the ordinary and you think this shouldn't have happened, they knew about it before it happened. They knew there were internally bad tests, or they internally knew about other complaints. And so that's obviously the critical evidence, because it's one thing to come in and say a company was negligent because they didn't design a product, and your expert gets up and says it, their expert says it's not, and it's sort of a war of the experts. More often than not, the plaintiff's going to lose those. It's another thing to say, let me show you when they knew, and let me show you what they did, what they didn't do when they knew, and develop that timeline of their knowledge and discovery. And that's really what happened in the Melton ignition switch case. It really wasn't some sort of extraordinary lawyering. It was just, we filed a complaint, we went through the process, we served our motion, they refused to produce documents, we went to the court, and they ultimately realized we got to give it up. And so we ended up getting documents showing this decade-long cover-up simply by using the civil justice system in a basic process of, hey, we're entitled to discoverable information, you need to give it all to us. And a tactic that I think is important we've seen recently is, particularly with a lot of electronic discovery, is the manufacturer says, we've done a search based on these terms, and these are all the documents we have. My point is, I don't care what you search on your terms. I've asked for these documents, and they narrowly say, well, we've used these terms, and of course, what that does is it restricts the number of documents. If it's an airbag case and they don't put airbag in their terms, then they're not going to get the documents you need. And so I would suggest, and don't allow them to sort of dictate the terms of discovery. Just say, I've sent a reasonable request. If you don't respond to it or don't produce all responsive documents, we'll go to the court.
Good. Yeah, and I love that Melton case. I've used that as an example many times, especially internally, talking to the folks who work here at Advocate about how important the work that our client base does, and beyond just the fact that you guys make money, and that's great. Everybody needs to make a living, and you're a for-profit business, but the importance of that particular case in getting, I don't know, hundreds of thousands or millions of basically death mobiles off the road is huge. And for that, I'm appreciative not only of you, Lance, but also all of our clients and all of the plaintiff attorneys in the country. The work that you do is incredibly important. We realize that. That's why we've chosen this business to work with. So thank you for that. And thanks for this information. We will now move on to, I guess, a little bit of advice, Lance. What advice would you give to a lawyer who's considering focusing his or her practice on representing plaintiffs in product liability cases?
The first thing is to join either the local trial association or the national trial association, and then get involved with the the product liability sections in those particular groups. There's nothing better. I mean, my first product liability case I handled in 2002, a long time ago, or no, 1992, a long time ago now. I had two lawyers up in North Georgia that were just great guys. They used to represent bootleggers back in the day, and then they got into product liability. And and so I called them up. I had a tire failure Bronco 2 rollover case, a tragic case where a young father had died as a result of this. I knew nothing, and that was back in the day that you didn't have this. And
Right.
So I got the Trial Lawyer, American Trial Lawyers magazine in the mail, and it just happened to talk about tire failures. And so I was just reading it and realized, and so I researched who the members were of that organization and found this Dennis, Kathy, and Ed Strain up in North Georgia. And I decided, I went up and met with them, and I said, they know a whole lot more about this than I do. I'm going to get them involved. They were very gracious about working out a fee with them, and they really just wanted to help and spend the time to help. And I learned so much from them in the first 3 years of litigating this case, as far as sort of the springboard. So I would suggest, and I'm not saying you have to refer your cases out. I'm just saying you should get involved with experienced lawyers. And most lawyers nowadays, because we have the internet, we have all these resources. You can email discovery to somebody, email a complaint. You can get up to speed, fairly quickly. I mean, there's a lot to learn about the inner workings of how product liability cases should be pursued. But, join these organizations and get involved as a younger lawyer. Whenever you start, you want to do that with other lawyers, because that's your best resource. And then really commit to learning your craft. As far as, if you're a product liability lawyer, I get an airbag case in, I'm going to learn everything I can about airbags. And because I'm technologically very, very old school. I don't really do technology well, as you know from our practice and for this webinar. I've had a hard time, but I think that you have to really take the time to learn whether it's the science or the engineering or the technology, because you have to be able to talk the talk and understand. But you have to be able to understand how to simplify it, because, use an aside, the first case I ever tried was a case against Ford back in 1995. And I had all the bells and whistles. I had a timeline, I had all this evidence and this and that. But I realized by the time I got my expert off the stand in the case, the jury was totally lost, because I had made the case much too technical, much too difficult. So it does get back to a certain level of trying cases is trying cases. And no matter what the case is, you got to understand what's the jury, not what the science is important for the engineers, but what's the jury going to get. And so I did. I went and watched Jim Butler's first side settle fuel tank trial in 1993, if I recall. A little small courtroom here in Fulton County. Went and watched Tommy Malone try some of his cases. He didn't do a lot of products cases, but he was a fantastic trial lawyer. So that's another piece of advice. We don't get in the courtroom enough anymore. I mean, I tried smaller cases when I was younger. I talk to younger lawyers now that when they go to these bigger products firms, it's hard for them to get in the courtroom. So go watch trials, because I think that particularly product liability trials, you'll see how it really works as far as ultimately what the end product needs to be.
And I agree. I've actually taken the time to go to civil litigation trials on occasion, because I'm fascinated by it. And sitting in the courtroom, you're right, that ability to take a rather complex set of facts and translate it for Jim and Jane Doe sitting in the jury box is incredibly important. Getting too technical, getting too fancy or technological is really a detriment to your case, because you just lose them. So I've always been fascinated by that, and that's really good advice. Let's see here. The next one is, what do you think is the future of product liability cases, particularly automotive defect cases?
Well, before I answer that question, I want to tell a quick story, and I'll just real quickly. Ed Strain, the gentleman I was telling you, one of the lawyers up in North Georgia who I was working on that first case with back 30 plus years ago. He and I went to a product liability seminar in '94, a couple of years later. And Ed at the time was almost retired, but he was, his career had been going on a while. And he sat me down. I said, Lance, he said, I know you want to be a product liability lawyer. He said, but product liability cases are going the way of the dodo bird. He said, Car companies are making airbags now. They got these automatic seat belts. They got this, they got that. They're smart. They got smart engineers. And I think, these cases are going to be much less, there are going to be much fewer cases in the future because the manufacturers are figuring out how to make people safe. Thankfully, I didn't take his advice. And the main reason was I enjoy what I did. But I also realized, and I don't know if Ed was tongue in cheek, but I think he was pretty serious about it because it was good in that cars were getting safer, and they were with the airbag. But there's always something else. There's always something else. And I like to say it's the human condition. And that is there's always situations where people are going to cut corners or they're going to make bad decisions. Right. It's just the way it is. And so I think the future is tragically, it really is tragically because, I do what I do, but I was meeting a case a few weeks ago for this family out west, this couple who lost their son in a GM case. And it just broke my heart, their story. And they were telling GM their story. And it's like, I love what I do, but at the same time, and we all can understand this, I hate what I do because I sit here and I have to listen to these stories, but they're going to continue. And just not to go on too long, but the example I used earlier about a crash avoidance technology.
Right.
We had a case. It was great. The car company put the technology in, and we had a mother driving and a young adult daughter in the passenger seat, both belted, driving down the road. Sun's in the mom's eyes. Log truck pulls out. She doesn't see it. She hits the log truck. Our vehicle had crash avoidance technology, forward collision warning systems, automatic emergency braking systems. We discovered that the car had been serviced and the dealer screwed up on the servicing. And so the technology didn't work and she didn't have it, the poor young lady in this passenger seat, the daughter was paralyzed. And so these cases, so that was a case where they put the technology in, it didn't work properly. But we're also seeing in many of these cases where they're not putting the technology in soon enough. And I'm sure most, if not all, the people on this webinar understand, the design defect claim is going to include failure to equip. And if you can show this company knew or should have known that they should have this technology. So all this crash avoidance technology, self-driving cars, I could show you videos of, them running over people because they malfunction. So you're going to see, we don't have sport utility vehicle rollover cases anymore. And the reason is because in 2002, Ford, they had this recall with the Explorer and the Ford Firestone, and all of a sudden the federal government got involved because of what trial lawyers had done, and they made sure that SUVs were lower and wider. And we don't have those because of what trial lawyers did. So I did a ton of that work. And what we did helped, I think, helped obviously improve public safety. But you're thinking as a lawyer, well, gosh, are there going to be future cases down the road because they're fixing this problem? Well, there's another problem, and there's another problem. And I think and that's where you have to be creative as a trial lawyer and push the envelope because the federal government they regulate safety, but it's really the civil justice system that does the best job of regulating safety. Because when these companies have to be forced to get into a courtroom and have to actually defend themselves and juries hear what they have to say about it, they realize, they're going to continue to get hammered by juries and unless they do something about it. And you've seen that time and time again. After the ignition switch problem that the ignition switch catastrophe that happened, everyone was asking me, can it get any worse for auto companies? I said, well, something's going to come up. And less than a year later, Takata airbag explosions came up because they covered that up. So it's always going to be something.
It is. And you're right. I mean, corporations are nothing more than a vehicle to generate a profit. And that's all they are. And so if you have corporations that do the public harm or turn their eye to the harm they're doing in order to continue to make that profit, the only way to punish them and to regulate them, as you said, is to hit them in the pocketbook. And so that's where the civil justice system does come in and the important work that you guys do, because it does lead to, I mean, I don't know that NHTSA would have ever gotten around putting all the dots together to recall all those GM cars that were recalled as a result of the Melton case. It's the civil justice system that really brought that to light, made it painful for GM, and made them make a change. So, and you're right, going all the way back to the SUV rollover cases, again, totally changed the dynamic of that industry. But you're right, the more this technology changes and more things come in, the more things there are going to be for them to turn a blind eye to. It's kind of like when you get a real fancy car that has all the technological gizmos, it's kind of like, all right, that's just more things that break, that go wrong. So anyway, great story.
One thing I want to say is that the GM litigation is a perfect example.
Mm-hmm.
The federal government knew about the problem in 2007 because there was a report saying that the ignition switch turned off in 2007. A trooper investigating a crash of 2 young ladies put it in the federal report, and photographs, airbags should have deployed, this and that, and it just went in some bureaucrat's file. And that Brooke Melton would be alive today if the government had done its job. And and they don't. I mean, they're not bad people. They just, more often than not, they don't do their job. And as a result, and I'll repeat myself, that's what makes it so critical for us to do ours.
It does. You're right. So I guess you kind of did just answer the question that was written. You kind of went off onto a story, which is fabulous. And then we did talk about what the future of product liability cases are, especially automotive defects. Because I think you went in and said, basically, they're still going to be around. These companies that manufacture automobiles are still going to make mistakes. They're going to put dangerous products on the road, and they're going to probably try to cover up issues that will make them less profitable. So I think there any other items you want to add to that, to this particular topic?
No, I would say the future, what's interesting about the future is, and it gets back to the government issue, and that is we don't see very many airbag cases anymore, that many seatbelt cases like we used to, but we are seeing, and other lawyers that I talk to around the country who do this work, we continue to see these seatback failures, and that is drivers driving at speeds of 30 to 40 miles an hour, running into the back of a car, and the seats failing. And the worst cases, and we have one in our office, is the parents are in the front, the children are in the back, the parents fly back as a result of, and so they end up killing their child because they cause their child's death, put it that way, because they hit some part of their body on the child. And we see that. And so those cases, and the reason those cases are still present is because for whatever reason, the government has bought into the industry's lobbying on not changing the seat standard. So the seat strength standard is the same as it was in the 60s. So you see all these new seatbelt standards and airbag standards. Give you an example. They're required now to drive a car 35 miles an hour into a barrier with a belted dummy or an unbelted dummy in the frontal even. And the airbag and the seatbelt and the airbag only often are supposed to essentially lead to most moderate injuries. The 35-mile-per-hour rear impact crash almost always results in seatback failures and people dying or being paralyzed as a result. So I use that as an example of the failure of the government to do something. And now we as trial lawyers, this is still, unfortunately, the future of automotive safety includes seatback safety because they're not safe. The vast majority, I mean, I can show you crash tests, 20 miles an hour where a dummy's in the seat, the driver's seat, and the seat goes all the way back. I mean, it's just completely unsafe. And so those cases, again, they're out there because the technology really hasn't changed because the manufacturers are dragging their feet and the government's not making them do anything. So it's pet peeve's not strong enough a word. That is an outrageous scenario where we still have children at risk in moderate rear impact crashes, and the companies aren't doing anything about it. And this is pretty much industry wide. I mean, Mercedes, BMW, and Volvo, their seats are better, but the U.S. and Asian manufacturers really have a problem.
Wow, that's good information. I think we are now at the questions and comments phase. I know we have at least one question. So if any of y'all have any questions that have come up as we've gone through this, please type them in the question box. We'll get them over to Lance. But Lance, we do have one question. I'm just going to read it to you. It says, what should a solo practice attorney do if a PI or workers' comp case involves possible product liability claims and that attorney does not have the resources to properly pursue that part of the case?
They need to find a lawyer with expertise in that particular area of defect and just consult with them and see what they think about it. Because oftentimes it may not be okay. I mean, they need to go out and they need to go consult with an experienced trial lawyer in that particular area. And there are trial lawyers that, have special expertise in airbags and seat belts. And so I would check with the local trial lawyer association who the most qualified lawyers are in that particular area, and then consult with them.
Okay. And I think I remember you saying earlier that make sure that if there's any evidence that you have as part of your workers' comp or PI claim that may be applicable, basically try to do that as early as you can so that any evidence is retained.
Yeah, so, and that's a good point. I mean, in addition to consulting with another lawyer, is send letters out. And if anybody wants to email, we have form preservation letters. Send preservation of evidence letters to the insurance companies for whatever products are involved.
Right.
And get an investigator. And that doesn't normally cost too much. Or if you want to get with a lawyer to get an investigator, to go out to the scene, because oftentimes the scene has evidence that the police officers or the investigators don't gather for whatever reason.
Okay, great. All right, I believe, Lance, that is all we have. I really want to thank everybody for joining us today. If you have questions after the fact, you've got Lance's information here. My information will come up a little bit. Lance, I really appreciate you joining us. Let's see, there we are. And like I said, everybody that registered for the webinar will get a recording of this so you can go back through it. And like I said, if questions come up after the fact, you'll have Lance's contact information. You have mine. I really appreciate you joining us, Lance. Really appreciate all the insight. Like I said, there's nobody better to walk us through these things. You've had a great career in representing those who've been wronged by manufacturers, especially automotive manufacturers. Really appreciate your time and really appreciate everything you do for us.
Paul, thank you very much. I appreciate you giving me the time.
All right. Y'all have a great day. Thank you.